Okay, why don't we begin? My name is Archis Parasharami, and I'm one of the co-leaders of Mayor Brown's class action practice and a member of its Supreme Court practice. And I'm delighted to have you join us today for our webinar, Major Developments in Consumer and Employment Arbitration. Let me introduce my co-panelists, and then I'll give a brief overview before we get right into it. I'm first joined by Andy Pincus. Andy is one of the leaders of our Supreme Court practice. Andy has argued 30 cases in the Supreme Court, and most notably, 3 of the major arbitration cases in the court, including AT&T Mobility versus Concepcion, the Kindred Nursing Centers case, and Lamps Plus versus Varela. Kevin and I worked with Andy on Concepcion, and I've been lucky enough to work with Andy on Kindred and Lamps Plus as well. Kevin Ranlett is a partner in our class actions and Supreme Court practice as well. Kevin and I have worked together, and he's worked with Andy as well, throughout all of Kevin's career at the firm. Kevin has been instrumental in helping clients draft arbitration clauses and enforce them. The two of us have worked together on those issues, basically, I think, since Kevin's time at the firm. Carmen Longoria Green is an associate in our Supreme Court and appellate practice who has worked with all of us on arbitration cases in the Supreme Court, courts of appeal, and trial courts to enforce arbitration agreements. And notably here, Carmen has worked on the amicus briefs for the Chamber of Commerce with Andy and me in 2 of the cases we're going to be talking about. So that's the group. We're delighted to talk with you about arbitration. And if we can go to the next slide. We have what I'd call 2.5 points. The first point is the significant set of cases that have occurred in the Supreme Court. 3 cases were argued in the last month, and there was a decision this morning in a 4th case. So a really huge term for arbitration in the Supreme Court. And we're going to talk about those cases, many of which are enormously consequential for businesses. The half point, we'll keep it short, is just to provide some developments on what's been going on with arbitration in Congress, including recent legislation. And then we'll spend the last half of the conversation talking about the phenomenon of mass arbitrations, which we know our clients have been reading about in the press, and some have been unfortunate enough to experience. So we'll talk about how those mass arbitrations have come to be, how they are playing out, and strategies that we are developing for both drafting around that problem and fighting back against mass arbitrations. So with that, let's turn to the next slide. And we're going to talk about the cases in the Supreme Court. So I think, Andy, why don't we start with you?
Great, and thanks, Archis, and great to be with everyone. And we'd like to make this as interactive as you would like it to be. So if you go to the bottom of your screen, you'll see a chat icon. If you click on that, it will open a chat function, and you can send your questions or comments or things you'd like us to respond to. If you just direct them to hosts and panelists, we'll see them, and we can answer the things that are on your mind. As Archis said, an amazing 4 arbitration cases in the Supreme Court. So let's turn to the next slide and get right into the cases. As you can see, they were argued, 1 in November, and then the Supreme Court had arbitration month this month with 3 of the other arguments, and we have our decision in the November case. So let's go to the next slide and start getting into the meat of the cases. So the Badgero case, let me start with a little bit of background. The FAA, as we know, doesn't create a cause of action. But the Supreme Court has held that motions to compel arbitration under Section 4 of the FAA may be brought in the federal court even when the parties are non-diverse, when their alignment wouldn't support diversity jurisdiction, if the claim that is the subject of the arbitration motion could have been brought in federal court, so-called look-through jurisdiction. But Badgerow raises the next question. Motions to compel at the beginning of an arbitration proceeding. What about at the end? What rule governs access to federal court after the arbitrator has issued his or her ruling and a party wants to confirm or to vacate the arbitrator's award? Lower courts were divided on whether that same look-through principle applies or whether federal court jurisdiction is available only if the parties are diverse and therefore the motion to confirm itself was supported by diversity jurisdiction. This was sort of a battle between text and content and policy in the Supreme Court. In the motions to compel context, the court had relied on the text of Section 4, which expressly states that a motion to compel can be brought in federal court if the court would have had jurisdiction over the underlying claim. There's no similar language in Sections 9 and 10, which deal with confirming and vacating awards. And it turns out, because the decision was issued today, and we know that the court held that that lack of text was fatal and that therefore look-through jurisdiction is not available. What the court said is we're going to focus on text, not policy. And 8 justices said look-through doesn't apply to motions to confirm or vacate. And so the ability to get into federal court will turn on whether there's diversity jurisdiction based on the citizenship of the parties to the motion to compel or vacate. The argument focused on policy, and Justice Breyer dissented. He had a textual argument, but largely on policy grounds that it didn't really make sense to have federal courts involved at the beginning of the dispute about arbitration in terms of hearing the motion to compel, but saying that the access to federal court would be much more limited at the end of the process. Obviously, this will limit the ability of parties to get access to federal courts. What are the practical consequences? Well, on this issue, probably in our experience, and obviously others may want to comment, federal courts have been more willing to respect the FAA's limits on reviewing arbitrators' decisions. State courts may be less willing to do so, and therefore the state court, federal court choice may depend on which side of that the party seeking to go to court is on. Do you want to confirm the award, or do you want to go to a court that's going to be more skeptical? In the consumer and employee context that we're focusing on, this has probably been less of an issue just because, as folks know, plaintiffs' lawyers are focused at the beginning of the process, whether they can stay in court, and they're much less concerned about what happens in the arbitration if the defendant is successful in forcing arbitration. So a limit on the availability of federal courts at the end of the arbitration process. But also, I think this case raises some other questions about other issues that arise in arbitration that, Kevin, I think you were going to raise.
Yeah. And then also one practical point. If you are worried about having to fight in state court about whether to confirm or vacate an award, one way to help this is if the case initially starts off in court and you move to compel arbitration, be sure that you get the case stayed rather than dismissed pending the outcome of the arbitration. Because if the case is stayed, you get to stay in federal court for the proceedings at the tail end to confirm or vacate the award. But in terms of other implications for this case, Andy, Archis, Carmen, I feel like this is going to spawn a whole new set of parallel disputes, some of which might ultimately come back to the Supreme Court. So the court said, Andy, as you pointed out, unless there was that phrase in Section 4 of the FAA that makes clear that federal courts can hear petitions to compel arbitration, that's not in Sections 9 or 10, the provisions that govern proceedings to vacate or confirm an award. But there's lots of stuff in the FAA that just talks about going to court and doesn't have those magic words from Section 4. So I expect to see parties fighting now over whether federal courts have subject matter jurisdiction to entertain requests to issue subpoenas in aid of an arbitration, that's Section 7 of the FAA, to appoint a replacement arbitrator under Section 6. This is an issue that is flagged by one of the footnotes of the decision, so I'm sure that parties are going to pick up on that. And then finally, there's been this long simmering background fight over whether these other provisions of the FAA even apply at all in state court. California has been the skeptic in this front. They had said a long time ago that sections 9 and 10 of the Federal Arbitration Act, the federal standards for confirming or vacating awards, don't apply in state courts. Very few other states had ever even noticed this as an issue or have ever litigated it. But I expect a lot more of them are going to be asked to say that we don't have to follow the FAA's limits. And Justice Breyer's dissent flags this as a possibility.
Yes, so I guess there's, especially with the growth of arbitration and the focus on arbitration, you can expect that various parties are going to raise all of these issues depending on whether it gives them a tactical advantage. So stay tuned. And certainly the last issue that Kevin flagged about whether the FAA's limits on the review of arbitrators' awards are going to apply in state court will be important. I think, Kevin and Archis, correct me if I'm wrong, most states have similar kinds of restrictions on the review of arbitral awards. So it's not as if you go to state court and the state court says the FAA doesn't apply, you're without any hope. But of course, state courts can interpret those state law review principles very differently than the way that a federal court would. And that could lead to much more intrusive review of arbitrators' awards.
Yeah, I agree with that, Andy. And I mean, I think, and you'll make this point, I'm sure, that the other aspect of it is that even if in theory they're applying the same standards, by and large, the state courts are far more hostile to arbitration than federal courts, and frankly more hostile to business. By and large, that's an overgeneralization, but.
So why don't we turn to thank the Supreme Court for giving us news today by issuing its decision in Badger Row, and we'll turn to the next slide and the next case. In most cases, the defendant decides at the outset whether or not it wants to invoke an arbitration agreement, and if it does, it makes the motion to compel arbitration in its first court filing, or certainly flags the fact that it's going to move to compel arbitration. But sometimes a defendant doesn't do that and engages in litigation in court. Maybe the scope of the arbitration agreement is unclear, or whether the plaintiff was bound by it is not clear. And so the defendant may engage in some litigation in court. That's what happened in this Morgan case. The defendant filed a motion to dismiss an answer, engaged in mediation. There was some concern about whether the arbitration clause might permit class arbitration until after the Lamps Plus decision. That may be one reason why there was delay here, but there was delay. And so when the defendant did move to compel arbitration, the plaintiff said, no, too late, you've waived. In this case, the Eighth Circuit applied a three-pronged test. Was there knowledge of the existing right to arbitrate? Did the defendant act inconsistently with the intent to arbitrate? And was there prejudice to the other party? And the court found no waiver because it found no prejudice. But other lower courts only apply the first two elements and don't require proof of prejudice. So the plaintiff filed a cert petition and argued that requiring prejudice is inconsistent with the FAA rule that arbitration contracts should be placed on an equal footing with all other contracts, arguing that courts find other contract rights waived without proof of prejudice, and therefore that same rule should apply in the arbitration context. Sort of ironic that here we had the plaintiff side invoking the equal footing doctrine, which has been something that defendants have used for years to protect arbitration agreements, but here they are. So that was the plaintiff's basic argument. The plaintiff also said, why do you want to reward delay? You should incentivize defendants to move quickly, and requiring prejudice gives them an out if they don't do that. The defendant side said, actually, this isn't a state law question at all. Section 3 of the FAA requires prejudice by mandating a stay of the action unless the party moving to compel arbitration is, quote, in default, and argued that default was something that requires proof of prejudice. And they said, even if the state law waiver rules supplied the rule of decision, they should require prejudice because delaying in invoking arbitration is more akin to laches or estoppel than waiver, and those two principles require proof of prejudice. And also they said the FAA is to promote arbitration, requiring finding waiver without proof of prejudice is going to hurt the availability of arbitration. The argument was pretty interesting in the Supreme Court. Lots of sort of federal courts kinds of questions. Is this a question of state law, or is it a question of federal law? Maybe some justices said that the Section 3 language makes it a federal law question, but then some other justices said, well, maybe the Section 3 language just incorporates state law. Concern that if state law supplies the rule, there'll be a lot of uncertainty and a lot of patchwork, different rules for different states. Even in the contract context, it may be difficult to figure out what the state's general rule is about waiver of contract rights. Did that make sense? Would that create delay? And then an argument that maybe this really is like waiver, like estoppel and latches, and therefore should require prejudice. On the other side, concerns about gamesmanship by defendants and waiting, and why should that happen? I'd say based on the argument, we don't know how this case is going to come out. There certainly was not much sympathy on the court for delaying. Justice Kavanaugh said in the DC Circuit, we adopted a rule that you have to raise the fact that you're going to compel arbitration in your first responsive pleading, and he asked why that wasn't a pretty sensible rule that the court should look to other, regardless of sort of how these other principles got resolved. So I would say we don't know how this is going to come out. As today's decision shows, this is a court that is focused on text and is not necessarily going to reflexively rule in a pro-arbitration way. So the bottom line to me is, whatever the decision that comes out here, it's going to put a premium on defendants raising claims to arbitrate early and not getting caught up in whatever legal standards the court is going to adopt, which could be very unfriendly to people seeking to compel arbitration.
So I agree with that, Andy. My sense is that for practical purposes, anybody who might have an arbitration issue, definitely raise it early. Ideally, raise it first, like the rule that Justice Kavanaugh put forward. Maybe we will get lucky and the rule will give extra time. But I will say that in practice, virtually none of these cases get to the Supreme Court. This issue had been granted, I want to say, in the 2000s, and then the case settled. So it took like 15, 20 years for it to come back. I think if you face a hostile district judge, that's a problem. So the best practice is certainly to move early. I think that the company wasn't helped by the fact that it didn't even raise arbitration in its answer. Historically, arbitration has been an affirmative defense, so you would think you could raise it in an answer. And I just wonder if this case would have been litigated and looked differently in the Supreme Court if it had been in the answer, but it wasn't. So I think that has unfortunately made things a little harder for all defendants. But kind of the key takeaway here is, raise it early, and absolutely don't, at a minimum, don't forget to put it in the answer.
But we'll get some definitive guidance from the court sometime before the end of June. So with that, why don't we go to the next slide? And Archis, I think you're going to talk about Southwest.
Yeah. So if we can turn to the next slide. Thank you. Southwest Airlines versus Saxon is a case that involves what the Supreme Court has called a narrow exception to the Federal Arbitration Act. It has colloquially been called the transportation workers exception. So if you don't arguably work with transportation workers, maybe this doesn't matter. Although I think it's actually still pretty interesting to get an insight into how the court thinks about arbitration generally and employment arbitration in particular. The FAA specifically says in Section 1 that it doesn't apply to, quote, contracts of employment of seamen, railroad employees, or any other class of workers engaged in foreign or interstate commerce. And this last phrase, any other class of workers engaged in foreign or interstate commerce, is referred to sometimes as the residual clause. In Circuit City versus Adams in 2001, some had argued that the Section 1 provision, this exception, was designed to invalidate all employment arbitration, and that the phrase class of workers engaged in foreign or interstate commerce basically meant any employees in interstate commerce, period. But the court rejected that, which is good news for businesses, because otherwise you would have no employment arbitration. Instead, the court said that the residual phrase has to refer to what came before. It has to look like either the categories of seamen or railroad employees. And so this issue kind of had been dormant for a while, but then both with the rise of effective class action waivers post-Concepcion and the Epic Systems case, and a case litigated a few years ago called New Prime versus Oliveira. In New Prime, the court essentially gave new life to this exception by concluding that the phrase contracts of employment swept beyond purely employees and could also cover independent contractors. And so that generated a ton of litigation, particularly in the gig economy. The Southwest case didn't involve the gig economy, it involved airlines. And so the particular type of worker was somebody called a ramp agent supervisor. And their job is to oversee employees who load and unload baggage from planes. And the plaintiff said, well, I'm a transportation worker. And so the question presented to the court was, does this exception apply to workers who load or unload goods from vehicles, here planes, that travel in interstate commerce, but who don't physically transport the goods themselves? From the argument, it's unclear exactly how it will turn out, but it seems to me like a number of justices on the court were skeptical of the idea that somebody who was actually involved in putting bags on planes was somehow outside of this exception. And at the same time, there were really great questions prompted by the respondent, by the workers' arguments about, well, how far does this stretch? And I think these are just opinions, and this is probably a very good time to put in the disclaimer I should have put in at the beginning, which is that our views are our own and not the views of necessarily of the firm or our clients. I think that the respondent thought she was ahead, and so she went. The counsel went for broke and said, maybe this applies to everybody who works for the airline, prompting this terrific question, I think, from the Chief Justice. Well, what about the general counsel of the airline? Is the general counsel an exempt transportation worker? And I think the answer has to be no. But where to draw that line is a problem. And I think as the argument evolved, it became pretty clear that there was more energy for a narrower reading than a super broad reading that covers all workers who work for a company that's involved in transportation. But it does seem likely that this particular type of employee may be exempt. And then one piece of the subtext was that, as I mentioned, a ton of the litigation in this area in the lower courts, we're involved in some of it, involves the gig economy, involves companies like Lyft and Uber, which filed their own briefs. We, Andy and Carmen and I and our partner Dan Jones filed an amicus brief for the chamber in support of Southwest. But Lyft and Uber have had a ton of litigation in this area. There was a question about that. And interestingly, the respondents' counsel seemed to all but concede that those sorts of workers are not like railroad employees or seamen. So that I thought was pretty interesting. And there's also been a lot of litigation that Amazon in particular has actually been losing a lot over whether the last mile delivery drivers are covered. And it seemed like the respondents' counsel was conceding that too. So it'll be interesting to see if this decision, which may well be a loss for Southwest, is nonetheless overall much narrower than the plaintiff's bar has been seeking.
Yeah, I think that's right, Archis. It seemed to me that the court was very leery of saying anything too broad because, again, this is a court that focuses on statutory text. So a lot of the discussion was what was included within the categories of seamen and railroad employees in 1925 when the FAA was enacted. And I think a lot of uncertainty about how those things might translate into a general rule, but it seemed at least some justices thought it was clear enough that people who load and unload goods from an airplane or a railroad car or a boat qualified as another class of workers engaged in foreign interstate commerce. But it also seemed clear that the court was very reluctant to adopt some very broad test that was going to deal with everything because it recognized that there's a lot of uncertainty in this area, and dealing with specific facts was pretty important.
It was fascinating to me that the number of times the word stevedore was mentioned in an argument, which is not a word that I've ever used in casual conversation, or Justice Gorsuch talked about wharfage, which is in the text of the statute. But as you say, Andy, I think this is a court that is hyper focused on text, and also that maybe kind of a more general view of the court as split liberal versus conservative, or pro-business versus anti-business, doesn't really, whether that's true or not in a general sense, you can debate that, but certainly in the statutory context, it doesn't really seem to hold water. New Prime was written by Justice Gorsuch, and it's essentially an anti-business but textualist decision. So it'll be super interesting to see what happens in this case for a number of businesses that operate in this area, and also more broadly for the structure of the FAA. So we should maybe then go to the next case, which I think Carmen and Andy are going to take, Viking River, which I think is probably the most consequential of the cases on the court's docket.
Yes, happy to get started on that. So this case came up through California State Court, which of course is relevant because Justice Thomas has consistently said that, in his opinion, the FAA does not apply in state court. And the plaintiff here, Ms. Moriana, she filed suit against her employer under California's Private Attorneys General Act, or PAGA. Now, PAGA authorizes employees to seek civil penalties for labor code violations that they and other employees experienced. So when they win these civil penalties, 75% of the penalty for each violation is paid off to the state, and the rest is to the wronged employees. So both the state and the wronged employees will receive a payment after a successful PAGA claim. The plaintiff here had agreed in her arbitration agreement to resolve all disputes with her employer through bilateral arbitration. And she had specifically agreed that she would not bring a private attorney's general action. So when she nevertheless filed suit against Viking River, asserting a PAGA claim on behalf of both her and all other employees who may have experienced labor code violations, Viking River sought to enforce the parties' arbitration agreement. And the Court of Appeals of California found that this was a run-of-the-mine application of Iskanian versus CLS Transportation. This is a California Supreme Court decision that held you cannot enforce arbitration agreements that purport to waive the ability to bring representative PAGA claims. And the California Supreme Court's rationale was that PAGA claims are analogous to key TOM actions. It is a civil enforcement action. It is an ability to seek civil penalties on behalf of the state. And so the ability to bring that case actually belongs to the state. And you can't waive that ability as an individual signing an arbitration agreement. So according to Iskanian, the FAA simply doesn't reach PAGA claims because it's not a kind of dispute that's between an employer and employee. It's a dispute between employers and the state. The Ninth Circuit, for its part, has also looked at whether waivers of PAGA claims can be enforced. In a case called Sakab versus Luxottica Retail, the Ninth Circuit took a different approach. It agreed with the California Supreme Court that you can't enforce waivers of PAGA claims, but it had a different rationale. It said that PAGA claims are fundamentally unlike class actions, so Concepcion and its rationale just didn't apply. There is no need to protect absent individuals' due process rights in a PAGA claim because those PAGA claims don't actually belong to the other employees at all. The PAGA claim is just a mean to obtain payment of civil penalties. And that would mean you can arbitrate a PAGA action without needing to get rid of fundamental attributes of bilateral arbitration, like a use of informal procedures. And so for that reason, the Ninth Circuit found that the reasoning in Concepcion, which says that you cannot use as a state law rule that would change traditional attributes of arbitration, you can't do that without violating the FAA. The Ninth Circuit said, well, that just doesn't apply in the PAGA presentation. So the issue before the court in Viking River is whether under Iskanian's reason or Sakab's reasoning, does the FAA require the enforcement of arbitration agreements that waive the right to bring representative PAGA claims? And the oral argument in this case was actually yesterday, and it was fascinating to watch. The petitioner, Viking River, argued that, of course, this is incompatible with Concepcion. Concepcion stands for the proposition that the court has consistently protected the key features of bilateral arbitration, whether it was a class action waiver, as it was in Concepcion, whether it was a collective action waiver, as it was in Epic Systems. Anytime you are purporting to bring claims on behalf of third parties, benefiting third parties, you are changing fundamental attributes of bilateral arbitration. And the Supreme Court has been clear that you are not able to do that. Respondents, for their part, argued that this case is not like Concepcion at all, because PAGA is not a procedural mechanism like a class action or a collective action as it is under the FLSA. It is a substantive claim. And the court has never ruled that you can use a waiver in an arbitration agreement to completely do away with a plaintiff's ability to bring an entire type of cause of action. Respondents also argued that even a complex PAGA action is not incompatible with the traditional features of bilateral arbitration because, as the Ninth Circuit has said in SACOB, you don't need to be protecting the due process rights of other individuals, and it's not going to be as difficult for an arbitrator to continue to use informal mechanisms. And so Concepcion simply wouldn't apply. And finally, respondents spent a lot of time focusing on how a PAGA action is a means for the state to get civil penalties for violations of the labor code. And if you stop individuals from being able to bring PAGA actions, well, you're actually stopping the state from having its own interest and its own claim for those civil penalties to ever be paid out. During the oral argument, you could tell that Justices Kagan, Sotomayor, and Breyer, they were very concerned with that possibility. They were concerned that there was a substantive claim, a PAGA action, that individuals in California would simply not be able to bring at all because of that PAGA waiver in their arbitration clauses. And this issue of whether or not a PAGA claim is substantive or procedural mechanism like a class action came up again and again in the argument. And then Justice Alito, for his part, he spent a lot of time with questions that were pointing out how PAGA claims are very much like class actions. They're very much like collective actions. In fact, at one point, he asked respondents' counsel, maybe we shouldn't see this as a substantive claim at all, but maybe a type of joinder rule in which a PAGA action is really just a rule that says you can join a whole bunch of different claims on behalf of a whole bunch of different employees who experienced labor code violations. And a waiver of a PAGA claim isn't waiving a substantive claim at all. It's just waiving a particular type of joinder. So it would be very interesting to see what the court does with this. And certainly there are other potential applications and potential implications of this rule, depending on how the court comes out, that will affect other types of mechanisms that California has used in order to avoid waivers, waivers of representative actions in California cases.
Yeah, I thought it was a really interesting argument. Carmen, as you say, no surprise that Justices Breyer, Kagan, and Sotomayor were skeptical since they dissented in Concepcion and Epic Systems and Lamps Plus. They don't like the protection of individualized arbitration, so they wouldn't like it here. It seemed as if, it's always hard to tell from an oral argument, that the justices who have been supportive of that principle seemed to, and several of them at least, seem to recognize that PAGA raised issues similar to the ones that were addressed in those cases. But we'll see how things play out when the decision comes down.
I think we have some possible implications of this decision depending on how it comes down on the next slide. So could we move to the next slide, please? Yeah, Andy, do you want to discuss about the implications this would have for the McGill rule?
Sure. So in addition to PAGA, California has another strange animal in its law called the public injunction, which is available for many kinds of consumer claims. And weirdly, it's a remedy that benefits the public at large and doesn't really focus on benefiting the party who is the plaintiff in the case. So it's a way to get a very expansive relief, not individualized relief, to use the sort of arbitration terminology. And we've argued, and many defendants have argued, that the public injunction rule is very similar to PAGA in that it transforms an individual case into what is essentially a class action, because public injunction relief is essentially the kind of injunctive relief you would get in a class action. But both the California Supreme Court and the Ninth Circuit, as they did with PAGA, have said, no, arbitration, we don't have to enforce arbitration agreements that permit only an individualized relief, because public injunctions are different, sort of on the SACOB theory, that these aren't class actions, they're just a case by an individual. I think there's a strong argument that if the defendant side prevails in Viking, that will perhaps undermine those decisions that have protected the availability of public injunction relief. And I know in a case that my colleagues litigated, a district judge was persuaded to stay the case pending, even though it was a case involving public injunctions and not PAGA, to stay the case pending a decision in Viking on the theory that Viking could have a significant effect on how that issue turns out. So bottom line, Viking is important both for PAGA and public injunctions, and of the four cases, could be the one with the most significant implications, depending on what the court decides.
Andy, do you have any predictions on how it's going to turn out? I ask in part because I know we're going to be getting that question from our clients.
It's always hard to predict. I think that, and again, we filed a brief in support of Viking for the chamber and some other associations, so it's hard to associate, but I think there's a very strong argument, and the court seemed receptive, a number of justices seemed receptive to the argument that this should be treated the same way as the decisions that Concepcion treated class actions and Epic treated opt-in class actions. So fingers crossed, that will lead to a positive result for the business community.
Yeah, I know that's certainly what we all think in the brief that Dan, who isn't here, and UI and Carmen wrote. And I'll just put in a tiny plug for Carmen, who did a terrific job drafting that brief that did get mentioned in the argument. So we'll see.
Yep. Absolutely. Why don't we go to the next slide? So we're going to move from across the street from the Supreme Court to Capitol Hill. Next slide. And talk just for a minute about a statutory development. As people who are listening, I'm sure know, if you follow arbitration, for the past 15, maybe 20 years, the plaintiffs bar and its allies have been engaged in a battle on Capitol Hill to try and whittle away or completely overturn the FAA's protections, particularly in the consumer and the employment context. And those efforts haven't been successful. But they did succeed in a little bit of whittling away this year through the enactment of the statute that you see on your screen, sort of riding the concerns, obviously the very legitimate concerns of the Me Too movement, and sort of using those to allow and get a statute enacted that amends the FAA and allows a plaintiff at the plaintiff's choice to render inapplicable to a case a pre-dispute arbitration agreement or a pre-dispute joint action waiver or class action waiver, essentially. And this is sort of with respect to a case that is that relates to the sexual assault or sexual harassment dispute. So I think what this statute makes clear is that if you're faced with a sexual assault or a sexual harassment claim, a claim arising out of that kind of conduct, which is defined in the Act, the plaintiff will be able to render a pre-dispute arbitration agreement inapplicable. There's a little bit of a question about what a case means. Does that mean if, for example, a sexual assault or harassment claim is joined with a wage and hour claim, just because they're in the same case. Is the wage and hour claim also not subject to arbitration? That seems an unlikely reading of the statutory text, just because it focuses so firmly on protecting plaintiffs in the sexual assault and sexual harassment context. And there also was a colloquy on the Senate floor just before the bill was passed that sort of underlined that this is about claims for sexual assault or sexual harassment that are brought in a case, not unrelated claims. So that may be a way that plaintiffs try to broaden this exclusion, but stay tuned and we'll see. And as the effective date, claims arising on or after March 3rd, 2022. So obviously available now to with respect to new claims for plaintiffs' lawyers and their clients.
Kevin, do you want to start us off on well, I think the topic that will take us through the rest of the hour, which is mass arbitrations?
Yeah, absolutely. Let's go to the next slide. There we go. So the first thing I wanted to talk to everyone about is fair shake, because while mass arbitrations have been in the press, another equally important development has been the rise of these entities. Fair shake is by far the biggest and most successful that facilitate the filing of, for fair shake, consumer arbitrations. It's basically like this online service that will fill out the pre-arbitration paperwork for you and actually file the arbitration demand for you. And for an increasing number of companies that they go up against, they will also offer an attorney who will represent the customer in the settlement negotiations. But if that fails and the case goes to arbitration, the consumer has to arbitrate pro se. The thing to know is if you start getting these, pay close attention, because fair shake has the ability, they have a lot of money behind them, and they have the ability to really crank up their machine and start sending you lots and lots of arbitrations if they think that you are going to generously settle all of these claims and let them take their cut. Because despite how little work they do for the claimants, they're taking a 20% contingency fee from all of these settlements, including if you give the customer a credit, they want a cut of it. So if you do see fair shake, be aware that that is their business model. You are perfectly within your rights to refuse to let them step in the way between you and the customer with respect to private customer information. Unless you've got something, some kind of consent from the customer, you don't have to talk to fair shake if they're not really, the lawyer. And then secondly, try and get permission from fair shake to speak directly to the customer when you're settling these claims. If their lawyer gives you permission, and very frequently will do so because they don't actually want to negotiate the settlements, you can often quickly settle these claims in a way that actually makes sense for you and the customer. I know at least one client that has been targeted by fair shake, by the way, and has actually found itself making money off of the enterprise, because so frequently the customers who are using fair shake are customers who owe a lot of money to the company. And so the aggregate amount that they've been getting in counterclaims actually exceeds the amount that they have paid out to claimants.
Go ahead. Andy.
I was just going to say, it's fair to say you and Archis have lots of experience dealing with fair shake, and it probably, this is a flare being sent up, but if people are confronted with fair shake, they should probably get in touch with you all to get the details on how to navigate this process.
That's very kind, Andy. And I mean, I guess maybe we can move to one thing about fair shake is that it's different from the typical mass arbitration that we're about to talk about, because fair shake it essentially brings a lot of claims, but they're all sort of individualized and unique, whereas the mass arbitrations are basically the same claim. But fair shake is its own animal with its own principle, and Kevin in particular has spent a lot of time talking to the person. So
why don't we go to the next slide, and let's talk about mass arbitrations. So mass arbitrations are a very recent development. There was a group of firms that tried some mass arbitrations shortly after Concepcion was decided. And by mass arbitration, I mean You recruit a bunch of consumers or employees to lend their name to you. You fill out copycat arbitration demand forms. You mail them to the company. And then you say, look, company, I've got 1,000 people signed up, or whatever the number is. They want as big a number as possible. If you don't write me a big check to go away, I'm going to file these in the arbitration forum. And they will often do the math. They'll say, and here's how much you are going to have to pay in arbitration costs. Even if you win every single one of these arbitrations, you're going to be out this eye-popping number. So please just write me the check so I'll go away. It's as bald-faced as that. And in the early years, when plaintiffs' firms still had hope that they could get around Concepcion, they didn't really devote lots of effort to it. But especially after Epic in 2018, the machine has really cranked up. And big law firms with lots of money behind them are getting very good at recruiting customers and actually bringing the mass arbitrations. If you are interested more about the history and details of all of this, one of our former associates who's now a professor at Georgetown, Maria Glover, has a law review article coming out in the Stanford Law Review that goes over all of the gory details.
This is probably where I feel obliged to say that she did not get this idea from us, I don't think.
That's exactly right. What she did is she interviewed a lot of the lawyers who were bringing these mass arbitrations. And it is increasingly apparent that they're all talking to one another and sharing ideas. Why don't we go to the next slide? Let's talk about responding to the phenomenon of mass arbitrations. Different companies are doing different things. Amazon was hit with 75,000 threatened arbitrations, and 75,000 times the $5,000 per case in fees that they were going to pay, even if they won all of the claims, is a truly eye-popping number. Amazon made the understandable decision to just get rid of arbitration altogether to avoid having to pay those fees. Other companies have tried lawsuits to get out of the fees. Most of those lawsuits that I mentioned on the slide here settled, so we didn't get court rulings. One that Uber has filed is still pending. We might get some answers there, but the dominant approach of the courts has been to say, oh, if you're having a fight over whether you actually owe the fees, that's really an issue between you and the AAA to figure out, you and the arbitration provider. It's not an issue that courts are allowed to decide. Other companies have decided, well, here what we're going to get rid of the AAA, we're going to get rid of JAMS, the reputable providers, and we're going to switch to these new startup arbitration providers because they're going to handle mass arbitration in a way that's fair to defendants. To be frank, I'm skeptical of these new providers for a couple of reasons. Number one, because they don't have this long-standing reputation with the courts that, for example, AAA or JAMS has, there is this risk that courts might decide that the forum is illusory or unfair or biased or unconscionable in some way, and your entire program, your entire arbitration program goes out the window and you're back to facing class and collective actions. Another risk is that some of these new providers, what they basically want to do to make these mass arbitrations cheaper is they want to effectively convert them into almost like mini class actions. One of these new providers basically says, what we'll do is we'll just appoint one arbitrator. That arbitrator is going to decide all of the common disputes of fact and law, and those rulings will be binding in all of the cases. That sounds an awful lot like a mini class action. Why don't we go on to the next slide? So we're going to talk a little bit more about how companies can and should update their arbitration clauses. But one thing that has made the need to do so paramount is a very recent rule change by the AAA. The AAA historically has been the best forum for consumer arbitrations from a defendant's perspective because they had the best fee schedule. You don't have to pay the arbitrators by the hour. But what the AAA has done is they now have come up with a system where they can effectively take all of the cases in a mass arbitration, 10,000, I mean, no matter how many, And they've decided we're not actually going to look for 10,000 separate arbitrators. What we're going to do is we're going to take all of the cases and we're going to point them all collectively to a roster of maybe 5 or 10 arbitrators. And each of those arbitrators will be expected to decide each of those cases individually. And the reason that this change is so catastrophic for defendants is that once they have appointed the arbitrators in each of the cases, the AAA feels justified in charging the company for the lion's share of the fees of the $5,000 per case. So in the old days, the way a mass arbitration would play out is you would pay a tiny upfront filing fee per case, but then you would pay the bulk of the fee only if the arbitrator was actually appointed and the case was going to proceed. But now you're going to have to pay the full $5,000 for basically all of the cases right up front.
Kevin, because the appointments happen pretty quickly, right? That's the problem. And this will transition into, I think, the next slide and some of our ideas, but it almost seems like the AAA is effectively setting up a set of mini MDLs where there are a handful of arbitrators presiding over a bunch of cases, which is really, I don't think, what defendants believe they were contracting for. But the AAA faced, I think, what I would characterize as this practical reality that they couldn't appoint 10,000 arbitrators. So this is what they basically say, this is what we're doing. And they welcome, in a sense, or at least they've said they welcome contractual responses to what they're doing. So I think that's, if we can go to the next slide, that's a good place to talk. Already companies are revising their clauses to try and deal with this problem of mass arbitrations, as we say on the slide. Some ideas we think are better than others. We definitely have opinions on this because we've been promulgating our own proposed thoughts about how to revise arbitration clauses to deal with the threat of mass arbitration. So I'm going to talk about first the ones we like, and then the ones that I think we're a little bit more worried about. One that I think is a very good idea, and this is something that many clauses already have started to do, is that prior to having an arbitration happen, many arbitration clauses have a pre-dispute notice requirement where the consumer or employee has to provide a short statement of their problem and give the company an opportunity to resolve it prior to the arbitration actually commencing. And in fact, in ordinary, what I would call real arbitrations where, genuine consumers, employees with actual disputes, are raising them and they're not lawyer driven, and some, or if they're kind of brought as an individual claim by a lawyer, those tend to settle at that stage frequently. So it can be a very good device just in general for resolving claims before the need to pay arbitral fees or to actually, get into the arbitral forum. But there's sort of a more, there's a greater need and a greater benefit to having these requirements in the context of mass arbitrations, because if a claimant is required to provide genuine information about their claim and also real identifying information, then that can solve a lot of problems for the business. First of all, one thing that's been observed is this phenomenon that there are a lot of fake claimants because people sign up online. They might not even be a customer or employee, but one of the problems has been that you've had to go to the arbitration to get that resolved. So you have already paid the fee and loss, and the plaintiffs know that. But if they have to provide adequate information in the pre-arbitration notice, that is one way to get that information from the start. And then adding something like a negotiation requirement where you, at the company's option or the consumer's option or employee's option, could have a direct negotiation, whether it's by phone or video conference, is enormously risky for the plaintiff's side because the dynamic is they do not want to talk to their clients. And so this forces them to actually communicate with their clients and get their clients on the phone or on video with the company and its representatives. That is a real obstacle to the business model of aggregating large numbers of people and essentially using them as the plaintiff's bar calls them in the MDL context, inventory. It's a lot harder when they have to treat them like real human beings. So that's a potential benefit. The other thing that we think is critically important is what we call batching or mandatory bellwether proceedings. And what we mean by this is to have a few arbitrations go forward at a time and to preclude mass arbitration claimants from actually filing the arbitrations until the first batch is done. So this is just like in MDLs that have bellwether proceedings that go to trial while the remaining cases wait. Same idea, something like, and what we've typically proposed is on the order of 20 to 30 claims go forward in the first bucket, and those all have to get resolved before the next tranche can even file their arbitrations. Now, their statute of limitations would be told, that's the protection for fairness, but at the same time, you are not facing 10,000 arbitration fees due all at once. You're facing 25. And one of the benefits of doing it this way is that you actually do get to have some test cases, and cases tend to be, those cases will be resolved on the merits, and that may help reach a settlement.
I want to flag, Archis, I think that's a really important policy justification for this approach, which is, the mass arbitration game is really to prevent merits-based decisions and just force settlements based on the threat of huge fees. This bellwether process essentially forces decisions on the merits into the process, which I think makes it very defensible as a policy matter.
Yeah, I agree with that. I mean, I think that one big question, this is an unknown, no court to date has considered the enforceability of these provisions, but I think of a batching provision, for example, but I think that the MDL analogy basically says, courts, this is what you do when you have mass torts claims, and this is really no different. I want to hit two things that worry us a little. One thing that worries us, well, a lot really, is, as Kevin mentioned, some of the other arbitral organizations, we don't have a conceptual problem with using someone other than the AAA or JAMS, which are the most reputable organizations. But in practice, many of these organizations have put together their rules in conjunction with unfortunately, with some of the defense firms that defend companies in these cases. And so that generates an appearance problem that courts have jumped all over. DoorDash, unfortunately, faced a very negative situation before Judge Alsop because the law firm representing DoorDash had also worked with the organization to put together mass arbitration rules. So at least for now, we worry about that. And we do know that our clients are getting a lot of calls from these organizations seeking to set up meetings and the like. The other idea has been, what about just diverting all of the claims to small claims court? And there is actually a AAA rule that in theory could allow for that. There are two concerns with that. One is that it's actually not that hard for plaintiffs' lawyers to recharacterize their claims as federal claims or as larger claims that are outside the small claims court's jurisdiction. So then that problem, the problem of that recharacterization essentially undoes this, approach. And there's also this bigger picture concern, which is that if you effectively have an agreement that essentially allows you to compel a small claims court, but not arbitration, if that's in practice what's happening, then over time, we think courts will think that this isn't really an arbitration agreement that has the FAA's protections. Instead, it's more like just a class waiver without the FAA's protections. And in the absence of the preemptive force of the FAA, all of the good cases and potential cases we're talking about basically go away. And in states like California, then California can basically do what it wants as a matter of public policy because there's not federal preemption. I know we're at time, so I think we might just either, go to the next slides and cover any last thoughts that Kevin or others have. Maybe we won't walk through these potential challenges, just to know that these issues are untested. And so the plaintiff's bar is going to fight back because they like this mass arbitration phenomenon. But I would just say it does seem like drafting provisions that deal with this problem is clearly, at least in my mind, the best way to go, given the outsized threat of mass arbitrations.
Let's go to the next slide. I totally agree with Archis. Update your arbitration clause as quickly as you can, but there might be a group of people, a group of consumers or employees for whom you're stuck with your old agreement and you are facing a mass arbitration. So what can you do? Well, it depends on the strength of the claims that you're facing. If you're facing claims where you're extremely nervous about the merits, it might make sense to talk to the plaintiffs, have real settlement discussions, and if necessary, tell them, look, could we just do 2 or 3 test cases to inform like a global settlement. If they are convinced that you really do want to reach a global settlement, they're not going to pull the trigger necessarily and force you to pay all of the fees, because that's money that is burned and can't go into their pockets. If, however, that is not a possibility, it's a truly cynical shakedown of claims that you're confident that you're going to win. Well, number one, be 100% certain and gear up and win the very early cases, because they will snowball. But another thing that you need to do is you need to make this an expensive legal campaign for them. Make them talk to their clients. Do individualized settlement offers, so they have to have separate conversations with everyone. They can't just send out a single email that says, oh, they're willing to offer you $5 to settle your claim. Do something different for each person. If they've got 10,000 people, send them 10,000 separate letters that they have to read. And another thing that you should be doing while you do this is find the weakest claims, the bogus claimants. We've had a case where there was a dead claimant who had been dead since long before. Don't tell the plaintiffs this claim is frivolous, withdraw it. Instead, make them arbitrate that claim. When they eventually realize that they've got a big problem, an ethics problem, because none of them, of course, are ever vetting their clients. When they've realized that they're bringing claims on behalf of people who don't exist or are dead or whatever it is, they'll start worrying that somebody is going to report them to the bar, like a very frustrated arbitrator.
Yeah, I want to be clear that just on that what we're not recommending that the business make ethics threats. But I think what we're saying is that it becomes apparent to the plaintiff's lawyers that they have a problem when you highlight the existence of their failure to vet. Which is a very big deal, actually.
That's exactly right, Archis. Exactly right. And then at a minimum, find the strongest cases and settle them however you can on an individualized basis in an effort to get rid of those cases. You don't want one of those really strong cases being decided first, because if the claimants win an early case, they're going to show that award to every arbitrator. They're going to put it up on their website. They're going to use that to attract more claims and to win them. Well, I know that we're unfortunately well past our time here.
Yeah, why don't we go to the final slide, Kevin? And this is just where we say thank you to all for attending and for staying over. And please don't hesitate to reach out to any of us if you have questions, if some of these issues pop up. And as the term comes to a close, we will report back on the outcomes, especially in the consequential Viking River case. But thanks to everyone for attending. And again, don't hesitate to reach out. We hope you found this useful.